All right. Take your time, get settled.
Thank you, Chief Justice Ireland.
All right, let's proceed.
May it please the court, my name is Joe Hanafi. I represent the defendant appellant Manuel Barbosa from a conviction of murder in the first degree in Plymouth County, Brockton Superior Court for the murder of Hercules dos Santos. I would like to begin my argument by drawing the court's attention to the issue of the 9mm weaponry. There was evidence at trial that the murder bullet was a 380mm bullet shot from a 380mm handgun, and evidence was allowed at trial over objection of Barbosa of the admission of weaponry found at his residence of 9mm bullet and a 9mm clip.
But there wasn't there a strong instruction following
There
that?
was an instruction that they could only consider it in terms of familiarity with weaponry.
Is that
However,
consistent with our decisional law?
no, I would submit respectfully, Justice Duffley, that the case law says that weapons or a weapon that could have been used in the commission of the crime on trial is admissible in the court's discretion. The court at that juncture has discretion to admit it or not admit it. The case law also says, however, and this is the point that I need to make, is that weaponry that cannot or could not have been used in the commission of the offense on trial cannot be admitted, and that there is no discretion on the judge to admit it for any reason.
You don't think that's a little strong? I mean, I understand the Toro case suggests that it's not a great idea, but I don't know that I would say our case law puts it quite as black and white as you say.
Well, I would respectfully disagree, Justice Botsford, because not only does Toro say that, but the Richardson case that was, I think, an appeals court case interpreted it that way. And I would also say that the Walker case, a federal case that I cited in my brief, also takes that position. There's been numerous look by the justices into this particular issue, and in every case that I could find, and every case cited by the prosecution, the only time weaponry that wasn't used goes in as evidence without error is if it could have been used. That is to say, a gun that was seen on a defendant could have been the weapon because they couldn't prove, or they didn't prove, that that particular weapon was the one used, but it was similar enough to the evidence that they did have, so that evidence could be used because it could have been the murder weapon. But all the cases talk about the fact that if a weapon or weaponry could not have been used in the offense, that it creates error. Now, the Toro's case, the language was, and this was also repeated in Richardson, that unrelated weaponry is the prejudice of unrelated weaponry upon the defendant outweighs whatever minimal relevance there might have been in its admission. In other words, it was a prejudicial, the balancing of it tips in favor of the defendant in each case. And I would...
Was there an objection here?
Oh, yes, there was an objection, and it was denied. So I would say every case supports that, the proposition that the defendant is putting forth in that regard, Your Honors. And I would also like to bring up that because there was an objection, the standard of review should be prejudicial error. And I would also say at this point that the evidence against Mr. Barbosa was not strong.
Well, you had three witnesses who testified that he
Well,
received.
if I could respond to that, Justice Botsford, the three witnesses, all three first denied that they saw anything. This was a tiny apartment where there were 25 or 30 people. That the lights were out, there were strobe lights flashing, and the music was blaring. The incident happened within a few seconds, and there was really no testimony that would suggest that anybody had a clear view of what was going on in that mob, especially with the lights out and the strobe lights going. That is very disorienting. And I would also say that...
But, and correct me if I'm wrong, but there was at least the cooperating witness, whose name I'm forgetting right now.
DeMiranda,
who was going up the stairs. I mean, there were him, and I thought one of the others had actually seen fish on the stairs. It wasn't just the apartment, but it was going up and down the stairs.
Well, if I remember correctly, it was DeMiranda who said that's where he saw Barbosa. But DeMiranda was a witness who had twice implicated himself in the shooting. He had implicated himself the day after the shooting, telling his friend Julissa DeLeon, we got the wrong dude. Now, that's important because there was testimony that DeMiranda arrived at the party with 3 other people, none of whom were Barbosa. So he says that at a time I would submit that it was gushing from him right after the event. In the grand jury, Julissa DeLeon testified under oath that on another occasion, DeMiranda told her that the shooting was the result of one of DeMiranda's boys. Now that is an inference of one of those 4 people that DeMiranda arrived with.
Who did DeMiranda leave with?
DeMiranda left with, according to his testimony, Mr. Barbosa.
But wasn't one of the people that he came with the father of the baby?
Killa.
Well, Killa, Sandy Lopez.
Wasn't he one of the ones that DeMiranda, did he?
I don't know. I don't think Lopez
No,
arrived
you're
with
right.
DeMiranda, and
You're right.
certainly Mr. Barbosa didn't know him. But, so I'm dwelling on the lack of strong evidence, and the other is that, so twice he tells DeLeon that he was directly involved with it, or one of his boys was directly involved in it, and then he is also, I submit, really weighed down with bias, a motive to lie, certainly with respect to his deportation.
Go ahead.
Well, he was the subject of a deportation warrant as far back as 2008, which he had been avoiding. He also was charged with 5 felonies in Taunton District Court in September of 2008 for 5 felonies of breaking and entering with intent to commit felonies in automobiles. And he defaulted on those.
So wasn't it up to the jury whether to believe him or not?
Well, I would submit no, Chief Justice Ireland, because the jury never learned, one, that the commission of 5 felonies is a deportable offense, that he would have been at the mercy of the federal officials and certainly the state officials for knowing that he's in this difficult situation. The jury doesn't know that, so they can't even evaluate the.
When did those either probation or whatever the resolution of those 5 felonies, did that happen after trial?
The resolution of those felonies occurred before trial, about 5 or 6 months before trial. But that brings up another point, and that is that the disposition of those charges were based upon what I would call an incredibly lenient disposition of this man, because all 5 felonies were disposed of on what is called pretrial probation. That is to say, under the statute 276, Section 87, which allows for an individual to be placed on probation without admitting guilt and without having to face trial. That is, but you can only get that if the Commonwealth approves it.
And the significance of that for your argument is that this is the only way, the only disposition that would get rid of the deportation.
Well,
issue,
yes,
right?
that it was the only way that they could get rid of
Right.
deportation, which
Right.
is huge. Plus, the jury doesn't know the importance of the disposition of pretrial probation under 276-87. They're not aware of that, the mechanisms involved there. That's huge in terms of weighing the credibility of this witness.
So how was he cross-examined on this subject? There must have been some cross-examination.
That is to say, De Miranda?
Yeah.
He was cross-examined on that. But I would say, Justice Cordy, that he didn't have to or wasn't able to really perhaps understand for himself the magnitude of the 276-87 that he received.
But it's the witness's understanding of the benefit that they've received, isn't it? That's most important in assessing credibility, not that someone else, not the benefit actually, but the witness's understanding of the benefit. Or am I just misunderstanding?
Well, I'm not sure that it's so much what the jury sees in him as being cognizant of some benefit, and clearly he saw that there was a benefit to him. He walked out of the courthouse. But what the jury doesn't see is that, I would submit, that the Commonwealth played a huge role in disposing of his cases, which puts him into a cooperating witness situation, which was completely
Was counsel barred from going into that subject? Or was counsel, I mean, I'm just trying to figure out how defense counsel approached the cross-examination. It sounds like there's a lot of meat here to go after.
Well, he cross-examined on both the deportation warrant, the federal warrant, and also the 5 felonies. But what I'm trying to point out is that the jury, he didn't cross-examine Mr. De Miranda on the intricacies of 5 felonies impacting on deportation, because he does. I would submit that perhaps Attorney Bradel, I believe his name is, didn't necessarily understand the intricacies of that, and certainly De Miranda wouldn't. But the point is that that state of things existed at the time of trial, which brings us back to the point that I've spent too much time on, that this was not a strong case against Mr. Barbosa because of the fact that De Miranda had so much baggage. Having said that, I would like to move to the next discussion, if I may, and that has to do with the introduction over objection of the installation of a security system, a video system, and a police scanner for that matter, at Barbosa's residence. I submit that, well, first of all, it was objected to. Attorney Bradel suggesting that it was unfair to bring in evidence that suggested that Mr. Barbosa was some sort of crime kingpin. In my brief, I cited the case of Commonwealth versus Simpson, in which a police scanner, that is to say a security device, was deemed to be excludable, not admissible for any reason, because it was not probative of any issue. And I would say likewise in the present case, the security camera, its existence, was not probative of any issue, and that it created a sense that Mr. Barbosa was doing something untoward, if not illegal, at his home, and that is not a farce, and from there it's not a far leap to suggest or to create an inference or a sense that this was a drug den of some kind.
But what do you say about the Commonwealth's suggestion that it was relevant to defendant's consciousness of guilt?
Well, thank you for that, Justice Lincoln. I would respond by saying not only did the Commonwealth make that suggestion, but the judge relied upon that the security camera, the security device, was relevant to consciousness of guilt of possessing the 9mm weaponry. And I would submit that that's a double prejudice, because it invites the jury to think about the 9mm weaponry that I submit shouldn't have been introduced. And secondly, the security camera becomes then, is dragged along with that, I submit, irrelevant and inadmissible evidence to suggest that it's somehow okay that they can consider this evidence.
Well, how about, oh, I'm sorry. I was just going to go along with that. I'm sorry, I understood it a little bit differently. I thought it went to the fact that he had a security camera, wasn't it beaming into his bedroom?
Into his bedroom.
And this was in the aftermath of the killings. And this way, and it was there, and you said a scanner, so that the consciousness of guilt, would be related to him monitoring whether the police were going to be coming for him.
I think that was the Commonwealth argument. I'm not sure the judge did analyze it that way, but I believe it was the Commonwealth's argument. I would respond by pointing out that, first of all, the police arrived at the scene pursuant to a warrant.
It was 10 days after the murder, right?
Yes, and the security camera, the police arrive at the same time the security camera becomes useful. It's really a non-issue, because the security camera is only useful if the police are there to warn Barbosa. But as soon as the police arrive, it's already too late. So it's a false premise.
Was there any evidence that the security equipment was recently installed?
Not at all. Not at all.
Well, what did the DA argue in the final argument about the camera?
They argued that it was admissible to show consciousness of guilt of possessing the 9mm weaponry, and it was admissible to show that it was Barbosa using it to give himself a head start if the police arrived.
Well, they talk a lot about the police scanner. Now, again, this is Justice Cordy's question, but there's no evidence that he just got the police scanner after this murder, is there?
No, not at all. And I would also point out that in one case cited by the Commonwealth, I believe it's the Arias case, where the security installations or security devices were admissible because they suggested possession of drugs, whereas there was no such admissible evidence, and it was a drug case being prosecuted. In this case, there was no such, I submit, no such evidence admissible, so you can't drag along that security device into evidence based upon that false premise. And so I would just like to spend a minute, if I may.
You have 57 seconds.
Okay. The undercover sting, I submit, was manufactured evidence that should not have been allowed into evidence. It was a disaster in terms of giving false credibility to Mr. DeMiranda and certainly to Detective Klimas, who was not even there during the undercover sting. And I cited to the case of...
I'm sorry, the officer who testified was
Yes,
not there?
he was not there. He was
He
not
was
the one
not
who was
there. It was the detective who's offering, I would submit, hearsay upon hearsay, in an effort to glamorize the what is it to say, the righteousness of the police and the credibility of DeMiranda. DeMiranda was being managed by the police by that point. The sting, if DeMiranda called the police, as was testified to, the police should have said, you have no obligation to speak to that defense investigator, and let it be that. But what they did was, they said, let's do this. Let you tell him that you'll sign that affidavit, which is a lie, and then we'll set up this sting to get him. And then they're allowed to use all this evidence to just provide DeMiranda with the kind of credibility that is just outrageous. And that was also objected to. In fact, when DeMiranda testified, he was not allowed to testify about that undercover sting. It was cut off upon objection. And then it was allowed by the judge through Detective Klimas, who was...
Whose objection? DeMiranda?
It was
Who objected?
Oh, Barbosa objected to its admissibility, and it was excluded when DeMiranda was testifying. But when Detective Klimas introduced it, again there was an objection, and it was allowed in based upon a faulty premise that it was relevant, and I submit it was highly prejudicial. And
Thank you.
I thank you, and I rest on my brief. Thank you.
Good morning. May it please the Court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. The defendants raised many issues. I'm happy to answer any questions if you want to take things out of order.
What's troubling to me, and I have not read the transcript, so I don't know how this totally played out at the trial, but this focus on the 9mm ammunition, which is at best marginally relevant, surely the prejudice, it seems to me, far outweighed the relevance, and certainly our cases suggest that that's probably correct. That compounded by this whole security system, police scanner, which was admitted to establish a consciousness of guilt with respect to the possession of ammunition, which is not relevant, and the fact that he possessed the ammunition. I mean, it just seems to me to be terribly prejudicial with almost no evidentiary value.
Well, I would suggest that the Commonwealth addressed this prior to the start of the evidence and relied on Otsuki. And in Otsuki, you had a handgun was seen in the defendant's possession about a month prior to the trial, and the offense was committed with a different handgun. Also in Otsuki, there was quite a bit of other bad act evidence, including the possession of both 9mm firearms and ammunition, which is consistent with the murder weapon in that case, and .380 caliber as well. And so I would suggest in Otsuki, that weapon was not used in the murder, and yet it was admissible. It was found to be a proper ruling by the trial judge admitting it for showing...
I mean, just for starters, isn't there quite a difference between having a gun and having, in the defendant's, Otsuki's possession, and having ammunition and a magazine? That's right, in the house, not even in his room? I mean, that's not a great source of authority for this.
Well, I would suggest that the Commonwealth relied on Otsuki, saying just because the weapon isn't the one that was used doesn't mean that it's not admissible to show access and familiarity to firearms. And the language in Marchetti also supports that out of this court. And both of those cases are after Toro. And Marchetti says testimony regarding the discovery of a weapon, even if it is not the murder weapon, may be admitted to show familiarity with the type of weapon. So that's what the Commonwealth was relying on, and that is what the judge relied on when he made his finding. And I would suggest that it is probative in this case, because this is a Christmas party. Fight breaks out, and the defendant ends the fight by firing one shot into the people who are fighting hand to hand, and someone gets killed. And these are all, the testimony is, they're all young people, 15 to 20 people who are, young adults. The victim's 22, Jalissa DeLeon 17. They're all in that age range. And everyone knows that firearms and ammunition are not readily accessible. You can't just go buy them at the supermarket. They're regulated.
You don't think they're readily accessible?
I would suggest they're not readily
I'm not saying
accessible
legal, but
legally. That's the reason. It's not legal to just go out and get a firearm without going through the steps first, particularly among young people.
So the point is,
And I
this
would
fellow
suggest
engaged in
he
other
has-
illegal conduct?
He has access and familiarity with the type
he lives
of
in a house that has
firearm.
a 9mm magazine, and I mean, it's a stretch.
Well,
It also, doesn't it support the bad acts connotation that counsel was concerned about?
Well, and that's where the limiting instruction comes in. So I would suggest the Commonwealth relied on this court's decision in Otsuki, where you have a gun. The gun a month before is blue. The gun at the scene of the crime is black. It is not the same gun. And this court said it was a proper ruling in the judge's discretion, and we rely on that language in Marchetti. So the judge agrees with us after reviewing Otsuki and says it comes in, but he's going to give a limiting instruction. So I would suggest to this court that if you find that this is an abuse of discretion under Otsuki and Marchetti, then there's no prejudice. And I would suggest, and this is to answer Justice Cordy's question, isn't the prejudice here overwhelming? And I would suggest, no, it is not. The reason it is not is that there was a specific instruction in the final charge saying you can only use this for familiarity and access to firearms and ammunition, and then the prosecutor properly limited her argument in that same manner, saying this is to show his familiarity and access to ammunition, and that is relevant.
If it had been excluded, would all of this evidence about security cameras and police scanners have been admissible at all?
Well, I would suggest, yes, that it comes in on my consciousness of guilt argument, but
Consciousness of guilt of him having committed the crime.
that he wants to know when the police are coming.
But you don't know when it was installed.
No, but he's using it for that. The Brockton police scanner channel, the police scanner is on the Brockton channel. The police tested it that night at the execution of the search warrant.
So when they showed up, was he there?
He was there, yeah.
Hadn't run?
There
Nothing on
were
the police scanner?
He'd already been talked to by the police twice prior to this, and he knew, and it's undisputed he was present at the scene of the murder.
So he'd already
gave
been
us-
talked to twice. It was 10 days from the event.
Yes.
And you're going to use it to show
I would suggest
that
that's an alternative
knew
theory
he-
of admission. At trial, the prosecutor asked to get these the security measures in the house in as foundation for the 9mm evidence, showing that he had control of the entire apartment. That was the purpose for it, and to answer Justice Ireland's question earlier, that is what the prosecutor argued it for.
Did the prosecutor also argue or suggest that it was for another purpose?
No, the security man. This is her argument on it. It's at transcript 7, page 44 to 45. You also heard about the police executing the search warrant at the defendant's home, and while they were there, they found a very intricate security system, police scanner, pit bills. They also found a live 9mm round. They also found an empty magazine clip. Although the Commonwealth is not suggesting that those items were used during the course of this crime, it certainly shows the defendant's ability to possess and his familiarity with ammunition. So she used that evidence for the purpose for which it was admitted, kept it limited to that, and even said his familiarity with the ammunition. It didn't even go to the firearms, which the judge had permitted. I suggest she...
So it was one live round and then an empty clip?
There's a live round under the stove. There's a clip in a man's shoe that's in I think it's an ante-room off the kitchen, like a...
And no evidence that it was his shoe, is that right?
No, we had no evidence that it was his shoe.
He was not the only male living in the household?
No, there were 3 men present in the household at the time of the execution of the search warrant, and at least 2 of them lived there.
All adults?
3 men were adults, there's 2 women who are adults, and there's 1 baby. So I would suggest that the Commonwealth relied in good faith on this court's decisions in Otsuki and Marchetti, and as did the trial judge. If you find that that is not a proper exercise of discretion under Otsuki, I would suggest that there is no prejudice here, because this is very minimal evidence. It's given a limiting instruction, and it was used within the context of that limiting instruction. There is an alternative consciousness of guilt argument that I have put in my brief that the Commonwealth did not rely on in the closing argument, but showing, he wants to know what the police are doing. That's what the police scanner is, because he has been spoken to. The jury knew he had been interviewed by the police twice already. So I would suggest that this would not result in any prejudice to the defendant, and my reliance here is on Toro itself. I mean, Toro recognizes the relevance and said that, the weapon in that case could not have been admitted, but that even over objection, its admission did not require reversal because of the strong evidence.
Well, that's
and
case
because
specific.
of
You're right, that's
the
case
instruction.
specific. In that case, it was not
And I would
unfairly
suggest
prejudicial.
in this case also, we have limiting instructions, the proper use by the prosecutor, as well as strong evidence. Now, I know the defendant takes issue with the prior the identification evidence. And what we have is, I try to be very blatant about this in my brief, we have 3 identifying witnesses. They have all given inconsistent statements. Jonathan Andrade only made a prior identification before trial. During trial, he refused to acknowledge it. He said, I just identified them as being at the party. I didn't identify the shooter. Jalissa DeLeon initially
And
said...
you didn't have it in the grand jury? You didn't have Andre?
We had his prior identification. I think it was... I'm sorry.
In other words, did it come in substantively, his prior identification?
Oh, yes. These 3 identifications came in substantively, and the defendant takes issue with that, both for De Miranda within the text of his brief and also in the 33E argument for Jalissa DeLeon and Jonathan Andrade. So Jonathan Andrade's the person who, literally has to be dragged out of a relative's house from a bedroom closet to court under a court order in order to testify. He refuses to acknowledge his identification, but his prior identification comes in substantively that the defendant's the shooter. Jalissa DeLeon's the 17-year-old girl. Initially, she says she doesn't see anything. Then her story changes. She makes a prior identification prior to trial. She comes in at trial, says, I don't recognize him, I don't know, but then acknowledges her prior identification and then, in fact, does
prior
make...
identification of him as the shooter.
As the shooter, in a photo
dressed in
array.
a fashion that was consistent with what the other witnesses said the shooter was dressed in.
Yes, but also she makes... And then
Does she call... Somebody says Fish.
she calls him Fish, and she says he's the shooter. So she has made the prior identification. And then, despite saying, I don't know, she then does acknowledge her identification during the trial and makes the identification at trial as well. And then Jose De Miranda, there's been a lot of talk of Jose De Miranda. He initially says, I saw nothing. Then he testifies at the grand jury. Then he backtracks to the defense investigator and says, I didn't see the shooting. I'll sign an affidavit. Then he backs away from the affidavit. The affidavit's not true. I'm not going to sign that. And then comes in at trial and says, yes, indeed, it is the defendant who was the shooter. So those are the 3 identifying witnesses. In addition to that, I'm sorry.
No, you go ahead.
In addition to that, Jose De Miranda says that he followed the defendant out of the apartment and that the defendant made a phone call, and the phone call was, the evidence shows that it went to Nicholas Loring. That's a reasonable inference. The phone call goes to, if we have his phone records, it goes to Loring's mother's phone. Loring's mother testifies, my kids have my phones, I don't know who has which phone. Her son is white. Her son is Nicholas Loring. Nicholas Loring is the defendant's roommate. He's the defendant's, common law brother-in-law, the father of the defendant's niece or nephew. And then De Miranda sees 2 white guys come in a car and pick him up at Pick Park. And then they all separate after a short drive. So I would suggest that the defendant's statement in his statement to the police, Exhibit 41, he says, I didn't make any phone call. I went straight home. The physical evidence of the records and to Loring support De Miranda and refute the defendant's statement. In addition to that, De Miranda says the defendant asked me to lie. He's going to pay my way to Cape Verde if I tell the defense investigator I didn't see anything. And then he thinks better of it when it comes time to signing the affidavit. That will be inconsistent.
What was all that about? I mean, why is that okay for him to?
Right. Well, that will get us to our 3rd issue, and I would suggest the defendant at the beginning. I'm sorry. At the beginning of the trial, this gets hashed out in a motion in limine, and the defense attorney talks about this whole defense investigator. He's going to call the defense investigator. He's going to bring in DeMiranda's prior inconsistent statements. And the judge says to him, well, the bottom line is you intend to elicit this evidence in some way. And the defense attorney says, yes. And so he says, and this is at transcript 1, page 48. So he says, what do you want the court to do? And he says, what I want the court to do is to prevent the Commonwealth from drawing the inference that the defense investigator did anything wrong. Okay, that was his concern about prejudice. So there is an objection during DeMiranda's testimony as well as to Trooper Klimas's hearsay testimony.
But could I just ask you about that? You suggest that it was okay to get into this prior consistent statement because the defendant had said he was going to get into it. But at the very least, at least as I looked at these transcript references in your brief, it was part of your direct case,
Yes.
Trooper Klimas. You didn't wait for the investigator.
No.
I mean, I must
Well,
say, I'm trying to understand how could you get into this whole double hearsay, prior consistent statement when DeMiranda himself testified, yes, I said. I mean, I just don't understand it.
I think the idea of it is that where the defendant said, I'm intending to present this witness anyway, I'm going to put this investigator on the stand. I think that gave them, the wherewithal to say, well, we're not really arguing about this meeting with the investigator coming in, et cetera. So what happened is, what the concern of the defense attorney was, I don't want it to look like my defense investigator did anything wrong.
Okay.
And I would suggest that was done because while there was evidence that an undercover trooper went with DeMiranda to meet with the investigator, the defense investigator didn't do anything wrong. He said, here's the affidavit.
But what's the justification for all this hearsay?
It was to corroborate DeMiranda.
But on what basis was it permissible to corroborate DeMiranda?
To show that DeMiranda was, of course, DeMiranda came with a lot of baggage. It was to show that when he said, I called the police, he did in fact call the police.
But does that, I mean, usually when you have prior consistent statements coming in, it's because something has happened at trial to suggest that when he testified in that way at trial, that's inconsistent with some other testimony or actions that he took. And so then you can go back to something that was consistent with his trial testimony, correct?
Right.
But I don't see that playing out here.
Well, the purpose of it, DeMiranda testified first, and he was cross-examined on, his prior statement to the defense investigator. You said that you didn't see it. So that's in there already, that through the cross-examination of DeMiranda. So, because the defense is trying to bring out that he made all these prior statements. And so the prosecutor is trying to show that DeMiranda actually did do the things that he said he was going to do. And that was the purpose of this testimony. But may I state that there is no prejudice here because the trial judge gave a limiting instruction. This information you're going to hear from Trooper Klimas is only relevant to credibility. It's only relevant to determine.
That's just the point. It's this extra shoring up of the credibility of the Commonwealth's main witness.
But it's showing that DeMiranda did the things he actually did. If DeMiranda said, I contacted the police, and we don't put in any evidence that he did in fact contact the police.
That would be one thing to say, he contacted me, but to go through everything he said, and it's double hearsay. It wasn't even the trooper that was there.
And that's where the defendant's initial statement that he intended to get out this whole scenario anyway, and that his concern was that the defense investigator didn't look bad. And I would suggest that that is what the trial judge was attempting to concern himself with, and he did so. And that also brings me to a comment my brother was making earlier regarding DeMiranda's baggage, his other cases. There was significant cross-examination of DeMiranda on his other charges. Those charges came out of the Bristol District, Fall River and Taunton. And his testimony was that he received no promises from the Plymouth District Attorney's Office, and that we didn't assist him with those charges, and that, that is what that other county did. This agreement on pretrial probation is something that's done through the other county. Now, the jury heard about all of his other charges, and they heard how they were wrapped up, and they also heard about his federal matters, and they heard about that he had warrants out for him, and nobody, he's dealing with us on this case, and nobody's arresting him. They got all that information. And you would find it in transcript 3. It starts at 65. They're talking about the immigration matters. You've been in immigration court, yes. You did go, but you didn't go there because you came late. Are you in default in immigration court as well? They told me to get an attorney and go back. Like the jury heard all this, pages and pages, all the way up to transcript 375. The jury heard all this information. That's the point I was trying to make in my brief.
But the jury understands that you need to have cooperation from the prosecutor to get off on 5 felonies, and that the impact of that is not only the fact that you need the cooperation, but that you can't be deported because now you don't have felonies that you've pled guilty to for purposes of deportation.
I don't think that, anybody spelled out what deportation law is. I think what the import of that cross-examination is, you get this, the case goes away, and you're done. And that was very clear from the cross-examination, that he was getting these deals out of Fall River and Taunton, and meanwhile he's got this immigration stuff going on, and there's default warrants, and still he's wandering around downtown Brockton. So I would suggest that evidence came in, the jury was permitted to weigh it, and that this was a very strong case, that this was a very well-tried case, that the trial attorney's concerns about the hearsay and the security measures and the 9mm were expressed and objected to, and that the trial judge remedied them with limiting instructions, and the prosecutor strictly adhered to them. This is a strong case where the physical evidence supported De Miranda's statements and the prior identifications and in-trial identifications of the other witnesses, and I would suggest that this court should affirm the convictions. I thank you very much.
Thank you, Counsel.